Good afternoon. We start, of course, with the Senzo Meyiwa murder trial and the defence advocate Malesela Tefu arguing against the further postponement. He's adamant that justice postponed, justice delayed, is justice denied. The judge and his fellow defence counsel, advocate Zandile Mshololo, agreeing that court should resume tomorrow.
The constitutional rights of my client are deliberately violated by the court that I expect to be impartial. The court that I respect so much. The court that it is not my desire for its decorum to collapse. What it played itself here before the long adjournment in this court is definitely leading to the collapse of the decorum of this court. And that will be blamed to the same court.
Live now to our reporter Linda Mnisi, of course, in the trial for us. Linda, good afternoon to you. Man, oh man, this relationship between Tefu and the judge, really not great, is it?
Absolutely, but it's also with regards to the issue around court processes, right, Stephen, in terms of when exactly to make submissions for certain issues. And today we saw, those heated exchanges between the judge as well as advocate Malesela Tefu, because the judge is saying that, amongst the things that advocate Malesela Tefu needs to remember is that he needs to follow proper processes and proper procedure. He cannot speak when he's not supposed to speak. He listens to every party, but it seems there's an issue with, him standing up every time when it is not his turn. But that left advocate Malesela Tefu feeling like he's being excluded from the court processes and ultimately saying that that would be a violation of his client's rights. So we saw that take place, but ultimately, which in fact led to him objecting to the postponement of this particular trial to a lengthier, for a lengthier period. You'll remember that advocate Zandile Mshololo had requested a lengthy period, given the fact that she still needs to be furnished with more documents. Now that's in relation to the second docket, but advocate Malesela Tefu saying that, he's objecting to that lengthy period because there are a number of issues that he still wants addressed by this court, and one of them being the issue around the jurisdiction and this particular court hearing this matter, which is 636, right? And he's saying that among some of the issues that pertain to the issue around jurisdiction has to be the issue around the signing of the documents by the NDPP, Shamila Batoyi, saying that she in fact was not supposed to be signing those particular documents. That's the prerogative of the minister. He also argues that those documents were signed on a specific day when advocate Batoyi was not on duty, which he says was a Sunday. He also says that those particular documents, were signed way before his clients were arrested. He says that this court does not have the jurisdiction to hear this matter. Also around his client's right, the fact that they were arrested and have not been given an opportunity to even apply for bail. They were outside when they were arrested and did not even get that opportunity to apply for bail. So he says that because of all of those issues that have happened, he uses the words kidnapped. He says his clients were kidnapped from Johannesburg to Pretoria, and that this court cannot give that lengthy postponement given the fact that it does not have jurisdiction, Stephen.
And Linda, I mean, this is going to be very important. I mean, you keep coming back to the tale of the two dockets. There seems to be a lot of confusion around how all of this could happen. This seems to be quite an important moment in this case.
Absolutely, Stephen. It features prominently in the proceedings here in the Pretoria High Court. And if you looked at, cross-examination by advocate Malesela Tefu himself, making reference to some of the statements that were made in that particular docket, as well as the statements that were made in the 636 docket. But now, the issue around discovery during court processes is also another one that is important, furnishing the defense with every document in the trial so that they adequately prepare. And that seems to have been one of the steps that was not taken in this case. The state saying that the only team that was afforded the opportunity to be in possession of these documents, or at least this docket, was Advocate Malisela Tefo himself. But Advocate Zandile Mshololo did not get these particulars, and therefore she says that it, is a miscarriage of justice. This infringes on his client's right to prepare adequately for trial, and because there's also two theories in the second docket, it then brings about questions of who exactly should be in the dock. Should we be having more people in the dock or not? And that's why she sought clarity around the status of this docket, saying that she wants to know what is the status of the docket. And from the letters that we saw today, it's important to point out that we received two letters, an updated version which was sent right after the first one was read, in which the DPP in the South Gauteng division says that there is no status in this particular docket, and that the opinions was received from a junior state prosecutor with no merit. So at this particular point, it seems that that is a response from the NPA, saying that the contents of the docket has no merit, and that opinion was gotten from a junior state prosecutor, an updated one which says quite similar things, to the effect that there is no merit to this particular case being given to the court.
Linda Mnisi, thank you very much indeed for that live update. More coverage, of course, when court resumes tomorrow morning.